I have an hour and a half to discuss the question of enforcement. And to do this, we have a highly skilled panel. Before I introduce our panelists, I would just like to say a few words to indicate how we got where we are. We started with the Article 14 of the Model Law, which a few years ago essentially left it to domestic lawmakers to provide for a mechanism for expedited enforcement without specifying any uniform way how this could be done or prescribing any procedural route to achieve this. I personally always thought that the working group and the Commission at the time had given up a bit early, but I can remember at the end of that process, the last expert group we convened in New York, where only two experts showed up, Judge Howard Holtzman from the United States and Professor Abascal from Mexico, who at the time was the chairman of the working group. So with the three of us, we thought we could not move the issue forward in any significant way, and we ended up with Article 14 of the Model Law. It is therefore a rather felicitous initiative that was taken by the United States 2 years ago to revive the issue and propose, indeed, the preparation of a convention. That was discussed at length at a working group session which we had last week in New York, which led contrasted results, the total sum of which is that we expect the Commission session next July to give us a broad mandate to envisage all possible options in relation to that proposal. With that very basic indication, I would like to now proceed with the introduction of our panel. Our panel will be presided by Justice Chandrachud, who is the Chief Justice of the Allahabad High Court. I will not go into the long story of his many achievements. I would just like to remind everyone that as judge of the Bombay High Court, Justice Chandrachud specialized in constitutional, commercial, civil, and tax jurisdictions. As a senior judge, he presided over the division bench hearing intra-court appeals. He has been a speaker at Harvard Law School, Yale Law School, the Australian National University, and the University of Witwatersrand. He has been a speaker at numerous conferences, an expert at World Bank, Asian Development, and United Nations Environment Programme. He is an honorary editor of the Law Review of the Government Law College, and the Judicial Academy, which he headed, looks after the training of nearly 1,900 judges in the state. With this introduction, I would ask Justice Chandrachud to start with a presentation, and I would ask all speakers who will come after Justice Chandrachud to limit their comments to 15 minutes so as to leave some time for discussion. Thank you.
Thank you. I'd really begin by flagging some of the key issues which arise for discussion this morning. One of the first questions that a potential user of mediation asks is it enforceable? If that is answered in the affirmative, then all the benefits of cost, time, and relationships come together to make it the most appealing form of dispute resolution. Now, traditionally, as we know, there have been three fundamental foundations for tracing enforcement of mediated settlement agreements. first is treat it like an ordinary contract. So if you have a mediated settlement agreement, you can, and which is breached, you have a remedy in damages, you have a remedy in specific performance. But what happens about non-monetary obligations? What happens to an apology which is to be given in mediation? There are so many issues which cannot be capable of specific performance. So treating an MSA as a contract, which was one option really jurisprudentially, suffered from very serious limitations. The second thing is that the problem is that mediation may have been resorted to deal with a breach of contract in the first place. So treating an MSA as a contract really doesn't resolve the issue because you set back parties to the original position, which was that there was a contract which was breached. The second is that you treat an MSA as a court consent order, which is what we have tried to do in India, which I would come to in a moment. But then treating it as a court consent order relegates it to just an order of a foreign court, particularly in a transnational situation. And as we know, judgments and decrees of foreign courts are subject to very severe limitations on enforcement internationally. The third option, which we have pursued at several stages, is treated as a consent arbitral award. Now, how do you envisage an arbitral award after an MSA? One option is to treat it that upon arriving at a settlement, parties would be deemed to have appointed a mediator as an arbitrator, who would then render an arbitral award in terms of the mediated settlement agreement. The problem with that approach is that there are certain jurisdictions, I mean, in England, for instance, we have that same issue to a certain extent in India, is that there must be a dispute, present or future, which has to be referred to arbitration. Now, if a mediated settlement agreement has resolved the dispute, is there really a dispute which you can then refer to arbitration, which is one of the key issues which has arisen in the context of the New York Convention. So would the New York Convention, for instance, apply when parties appoint a mediator after a settlement is reached? So all the three traditional premises of enforcing arbitration, of mediation settlements, suffer from very serious problems. Now, what we have tried to do in India is that in the domestic field in India, if you have a court-annexed mediation, where a pending case is referred by the court to a mediator, and after settlement is reached, the matter goes back to the court, and the court will then pass a decree or order in terms of the settlement, in terms of what we call as Order 23, Rule 1 of the Civil Procedure Code. If this decree is not obeyed, then the provisions of the Code of Civil Procedure are applied for the execution of the decree through the court process, which can then be resorted to. But the Privy Council said many, many years ago that the travails of a litigant in India begin after a decree is passed and when execution commenced. For mediation other than court-annexed mediation, the act which applies is the Arbitration and Conciliation Act, of which Part 3 applies to conciliation. And broadly, conciliation and mediation has been understood as analogous in judgment of the Supreme Court in AFCON's infrastructures. Now, as regards enforcement, Section 74 of our Act provides that agreements which are reached in conciliation are automatically to be treated as arbitral awards by consent. So an arbitral award can then be enforced as if it were a decree of the court under Section 36 of the Act. Section 34 of our Act provides for a challenge to arbitral awards. However, where an award is based on consent, it is difficult to mount a challenge, and fraud or coercion or misrepresentation would be the limited grounds for mounting such a challenge. Now, what we really need to do is, I would suggest, is to create what we learned in economics as the Pareto optimal solution. A Pareto optimal solution, as they call it, is one which makes both parties better off, or makes at least one party better off without making the other worse off. What do we really regulate as the international community? One option is to formulate grounds to refuse enforcement. I think we're all pro-mediation, but we also need to realize that we have to formulate grounds to refuse enforcement in certain circumstances. And this is particularly a problem which I find in the largest and the most populous state in India, the state of Uttar Pradesh, of which I am the Chief Justice, because a lot of disputes are now being transformed from civil courts into the jurisdiction of the police, just because civil courts have not been efficient in dispute resolution. So you find that a lot of matrimonial disputes are handed over to the police to resolve. Disputes between neighbors are handed over to the police to resolve. And if a mediation is arrived at by a station house officer or an officer in charge of a police station, is that really something which I as a judge would want to enforce in the course of a mediated settlement? So 3 grounds possibly to refuse enforcement: where the agreement itself is invalid, or second, where there was an irregularity in the appointment of a mediator. I had a situation just a few weeks ago where the officer in charge of a police station asked a woman who was in a relationship with a man to go together and live together. Now, if that was supposed to be enforced as a mediated settlement agreement, I set it aside, saying that it was contrary to public policy. So these are certain very key issues which we need to look at. Or where the process of the mediator itself was flawed. Has the mediator done something which was radically wrong? Now, will a regulatory mechanism at the international level undermine principles of self-determination and consensuality? There's one view which says that, well, mediation is all about being consensual. Then why have an international framework? To my mind, that the answer is no. You need an international regulatory framework. The regulatory mechanism must firstly enforce compliance with the agreement to mediate. So if you have an agreement to mediate, you must enforce compliance. Parties cannot then say that I shall not mediate. We have precedents. We have the precedents of the English High Court in Cable and Wireless of 2002, Holloway of 2007, Sul-America of 2012, Grant and Thornton of 2012, and of course we have Chief Justice Sundaresh Menon's celebrated judgment in the HSBC Institutional Trust Services, where 3 broad principles have been laid down. First, was there an unequivocal commitment to engage in mediation? Second, was there an unequivocal agreement to enter into a clear mediation process? And third, is there a provision made by the parties for selecting a mediator? So that we have to have the ability, and I speak that as a judge, we have to have the ability as judges to enforce compliance with an agreement to mediate, that you shall go to mediation. The second, that we must recognize and enforce MSAs except on very limited grounds. And third, which is really an offshoot of the second, that we need to define the grounds for review. Now, when you define the grounds for review, it's very important to balance the need for confidentiality in the mediation process, which is possibly the hallmark of mediation, with the need to disclose, for the need to disclosure to the extent to which it is necessary for judicial review. Where do you draw the line? Where does a judge inquire into what happened in the mediation process? Was a disclosure which was made, because the mediator has a very significant role, perhaps in some respects even more significant as a judge, because a lot of what you do is private. A lot of what you speak to parties in the absence of the other is private. So at what stage is the need for confidentiality to be outweighed by the public interest and the need for disclosure when you review the legality of a mediation process? Perhaps a lot of these issues can be taken up if mediators focus on avoiding potential challenges to the agreement. And some key issues are, I just broadly flagged them. First, representative capacity. Corporate entities must be represented by persons having due authority. Where interests of minors are involved, legal safeguards have to be observed. Second, a failure on the part of the mediator to disclose an interest in the mediation or connection with the party can possibly vitiate a settlement. Third, breach of confidentiality norms can give rise to a complaint. Fourth, if the procedure followed by the mediator is unfair or improper, that would render the agreement unenforceable. Fifth, a lot depends therefore on the care and competence of the mediator. And therefore, I believe that the important issue which we have to address in this plenary session is how enforceability of settlement agreements can be made easier so as to retain the positives of mediation without the concerns over its effectiveness. For confidence in mediation to be built up, both nationally and internationally, parties need to be made comfortable that the result of mediation is enforceable And work needs to be done towards building that confidence, which is integral to the success and growth of mediation. Thank you. Thank you, Mr. Chair.
Thank you very much for those thought-provoking comments. I think we will leave the questions for the end of the time allotted to us, and without further ado, I would give the floor to Professor Nadja Alexander. Again, too many achievements for me to recall. Briefly, Ms. Nadja Alexander is the director of the International Institute of Conflict Engagement and Resolution and the professor of conflict resolution and law at Hong Kong Shui Yuan University. She has been listed as one of Australia's top 5 law academics by Businesswoman magazine. Please, you have the floor.
Thank you. Morning, everyone. I'm going to take a slightly different pace. I'm going to start with 3 very short stories. The first one is Varuna's story. I talked to a few people yesterday about their experiences and thoughts on cross-border mediation. So I might, Varuna, if I've got the story a little bit wrong, just forgive me. So this is a story of a family. Mum's from India, dad's from Virginia in the US. Parents separate. Mum takes son to India without consent of dad. International child kidnapping, FBI's involved, all sorts of actions before the courts in the US. Mediation takes place in India. The FBI comes over to India to check what things are like, the situation with mum at mum's place, and eventually there is a mediated settlement which takes the form of a court order in India, but not in the US. Mediated Settlement Agreement, MSA. Geeta, where's Geeta? Geeta has finished the conference. She's exhausted, so she wants to treat herself. She orders online a massage chair from a company that's in China. I know, you need that on high, girl, you will. But it doesn't arrive. Geeta finds herself engaged in an online mediation process which results in an agreement, right? Takes the form of an ordinary contract, let's say. And then there's me. I should say this is not true, but just imagine that I write jingles, advertising jingles in my spare time. And I'm in Hong Kong, and I write a jingle for someone based in Shenzhen that's just over the border, half-an-hour train ride, just over the border in mainland China. So I do the jingle. I'm supposed to be paid. The my client doesn't get paid at his end because his deal falls through. I don't get paid. I convince my client to mediate in Hong Kong, and we end up with an MSA, a mediated settlement agreement, in the form of an ordinary contract. So these 3 stories, a family story, a consumer story, and a small business commercial story, let's say. In most cases, people stick to their agreements. What this topic is about is when people don't, when somebody breaches the MSA, or, for example, Geeta has an agreement to get her money back, but she doesn't, or when somebody wants to get out of the agreement, right? Doesn't want to have to fulfill an obligation and tries to get out of it. So, here's a quote that inspired, my talk this morning. And this is by Rainer Maria Rilke. He was a 18th century Austrian bohemian poet and wrote in German, but this is a translation. He wrote, "Have patience with everything that remains unresolved in your heart. Try to love the questions themselves. Do not now look for the answers. At present, you need to live the question." And that's what I'm going to do. I actually want to open up the discussion, not try and zoom into to a solution. I don't want to take a view in this particular presentation, but what I'd like to do is offer, if you like, a process framework for thinking about these issues. And why a process framework? We're all mediation professionals. Why do we take people through a mediation process? We take them through a process so that everyone is heard. We take them through a process so that different points of view get an opportunity to air. We take them through a process so we can identify all sorts of issues, legal issues, but also non-legal issues. Right? We take them through a process so that we don't overlook options. We don't move into solutions too quickly. Why? Because we want to make sure that we have all options on the table before we move at the right pace, with the right timing, right, to an outcome that suits everybody, if possible. And so for all of those reasons that we know very well, my aim is to make you confused. No, not really. My aim is to open up this topic so that you have more questions at the end of this 15 minutes than you had answers. And if you thought you knew what your view was, I hope you're rethinking it, right? So I went around and talked to a lot of people yesterday. So I thought, what are people asking? What are the questions? What are the comments? And I actually tried to video people, so my apologies, that didn't work. But here are the questions summarised. Well, we need to encourage people to use mediation for cross-border dispute resolution. How do we do that? How do we make enforceability of that means international iPhone, MSAs easier? That's important. Is there really a difference between negotiated settlement agreements and mediated settlement agreements to such an extent that we should be treating them differently? If we do something special like expedited enforcement for MSAs, what about NSAs? Okay. What enforcement options are currently available? I actually don't really know. I'm in a common law setting, but what about the civil law options that are available? To what extent would a multilateral international convention on enforceability be useful? Not all MSAs are equal. Right? Can we separate, for example, monetary MSAs from others? And not all mediation service providers are equal. There's an issue of quality. When I was having this conversation, I was reminded many years ago, there was in Australia, I think it was about 10 years ago or something, there was a whole lot of court cases about the mafia or the gangsters in Melbourne. So the gangsters sort of were disagreeing and having a lot of conflict, and it ended up turning into a fantastic, hugely selling TV series called Underbelly. I'm not sure if anyone saw Underbelly. Some people are nodding. I think it was exported throughout the world. Well, one of the big gangsters in his life after being a gang leader set up a mediation service. I kid you not, right? I kid you not. And he was interviewed by the press. It was mediation and arbitration services. And he said, you got a problem? We fix it. Right? So, you know, there's not all mediation service providers are equal. And of course, implicit in this and in the conversations that we've already had is this question of, you know, should we move towards a multilateral convention? I affectionately call that NYC4M, a New York Convention for Mediation. And I actually want to steer us away from that as the focus. I don't have a view on whether it's where we want to go or not. Maybe it is. But I'm going to try and anchor the conversation elsewhere. I want to introduce a 5-step approach. It's nothing really special. It's pretty much a mediative type of approach. First of all, let's think about what is the problem to be solved? And I actually think, talking to people, that people see this as different. People have different ideas about what we're trying to do here. And why is it important? Well, that obviously depends on the problem itself. What exactly are we talking about? Which sounds like a simple question, but gets pretty complex. What are some relevant criteria that we can apply? What are the implications for enforceability when we look at, for example, the different characteristics of what are called mediation processes around the world? And what are some regulatory options in terms of form and in terms of content? So I'm not going to go into any detail clearly this morning, but I'm going to run you through some ideas and some questions related to these 5 steps. So what's the problem? Well, some people say it's low usage mediation, particularly in cross-border disputes. If we had something like an international convention, an NYC4M, well, everybody would go running to mediation. I think there's a lot of assumptions in that. If you look at a lot of domestic jurisdictions where there is legislation on enforceability of mediated settlement agreements, taking the form, for example, of a court order, it hasn't done away with the need to mandate mediation. And in civil law countries where that legislation also exists, and there are no incentives or financial incentives in particular to move people to mediation, there's still not a lot of practice happening. And there's various EU studies which show that. What about the lack of certainty? The lack of certainty, the lack of predictability in relation to enforcing MSAs. I mean, around the world there are very different mechanisms and they mightn't be recognised in all countries. So if we've got some certainty, even that we know whatever I have will be enforced somewhere else, that actually just might make the process more attractive. So enforceability for enforceability's sake, not necessarily to increase the usage. So, you know, these are the two main themes that keep coming through. Why is it important? Now, this is a really interesting question. Some people say, well, it's important because we have to promote amicable settlement. So then the question arises, well, all amicable settlement, right? Negotiated settlement agreements, why single out MSAs? Why single out mediated settlement agreements? Well, is it that amicable settlement with a third party, mediation, offers something else, offers a different quality, offers a type of due process? And if so, how do we define that? Right? Is that enough of a justification to treat these type of agreements differently? And is it important because we need to offer certainty and predictability in an expedited way for amicable settlement with or without a third party and with or without lawyers in attendance as well, right? So you can frame these questions in very different ways. So this is, I think, a particularly interesting point for me. What exactly are we talking about? So I think Joel yesterday introduced, I might have it wrong, the idea of a functional definition at lunchtime, something like that. So I'm going to use a look at a functional definition for, in particular, mediation, not necessarily international commercial. So what do we mean by mediation and what do we mean by enforceability? Because I think different jurisdictions mean different things. So here's a table. I'm not interested in the detail of the table. I just want to highlight a point. This table looks at characteristics of different processes which can be called mediation, although I've given them different labels. I don't want to argue about the labels, they're just labels. And the aspects of that process over which the parties may have control. So, on the left-hand side, your left-hand side, we've got negotiation, mediation, mandatory mediation, whatever model that is, conciliation, mandatory conciliation, court conciliation, settlement conference, neutral evaluation, arbitration and adjudication. Now, you might have a different name for these processes. You may not know the difference between some of them, but the point is around the world these labels exist. But what's important is the top row is actually the functions that these processes have and the differences there. So if we take away adjudication, oops, what have I done? If we take away adjudication, if we take away arbitration, and if for the moment we take away negotiation, then we've got a bunch of processes which, to my mind, seem to fit the UNCITRAL model law definition of conciliation, right, which we also know as mediation. And so you can see, just by looking at this, that we're talking about processes where parties don't always have control over when they initiate, whether or not they initiate the process. So what does party autonomy mean? Does it mean you have to choose to go to mediation? Does it include mandated processes? Not all processes are interest-based. Is that an assumption that we're making? Does that make a difference? If we've got, for example, an advisory or legal-based process with private sessions, right, how does that affect our idea of due process or not? Do parties have control over the content of the outcome? The more you move into conciliation processes in many countries, the less that's the case. And generally speaking, parties have power over whether or not they implement the outcome. Do you get to choose your neutral? Not always. Sometimes you do. To what extent does that affect party autonomy? Are you responsible for the information that's presented? Well, that seems to be true for most, if not all, processes. Oh, interest-based I talked about before. Oh, sorry, the second column was if you have control over the process. And the third one, is there a third-party intervener? Well, yes, in all of these processes. So what are we talking about? And I think it's easy to use the label mediation, but we can really be talking at cross purposes. I've been engaged in a correspondence with a senior judicial figure in Asia, and he very firmly takes the view that any sort of court-referred mediation cannot be subject to a multilateral convention on the enforcement of MSAs, because that affects the party autonomy to too great an extent. And I said to him, gosh, there's a whole lot of mediated settlement agreements that just aren't going to be covered by a multilateral convention if that's what you do. And he said, well, what's guiding me, right? What's the principle that I'm applying? The principle that I'm applying is if parties choose to do this, then there's every argument that you should have expedited enforcement. But if parties aren't choosing this, then I think you have to look very carefully at whether you speed up an enforcement subject to limited exceptions only. So food for thought. What are the implications of these definitions? I've talked about a few of those already. Are MSAs sufficiently different from NSAs? How does a third party presence affect due process? And how do we ensure, the third point, a quality check on the role of the mediator? Should, for example, we only be looking at institutional mediation and have additional requirements for ad hoc mediation? And how will that affect the practice of mediation? Because cross-border isn't just the big boys doing, you know, big money transactions and disputes. Cross-border is everything nowadays, even in commercial, even with my jingles. So what are we talking about with enforceability issues? So here are just some questions, right? Jurisdictional questions might arise about the extent to which an MSA falls within the scope of a clause, an agreement, or a referral. Not all provisions, and this has been mentioned already, may be suitable for expedited enforcement. How do you separate those? How do you manage those? And an expedited enforcement regime may have implications for the confidentiality of the process and or the outcome, right, where you put a confidentiality clause in the outcome. So we need to think through all of these things very carefully. What will the exceptions be? And what if the parties decide they want to vary by agreement their MSA? Can they do that afterwards, once we've got an expedited form? All right, so there's some of the issues, there's some of the questions, and there are many others. How do we think about this? What sort of criteria are relevant? What sort of guidelines can we use to help us make our decisions? Well, here are just some. I think clearly policy guidelines are important, and I was talking to a German colleague of mine. I've been spending some time at the Max Planck Institute in Hamburg, which is sort of a very intellectual German place, and this fellow was telling me about normative individualism. I sort of had to take two. But he said basically it just means, it's the principles upon which most international conventions and most laws and bills of rights are based on in modern legal systems: party autonomy, equality, and efficiency. So, you know, they should be predominant in any options that we choose. And here the questions are around the cost-benefit analysis of to what extent a new international legal infrastructure will change practice in a way that will benefit users. What about empirical findings? People have talked about that yesterday. What about interdisciplinary perspectives? There is now loads of research on cultural, historical aspects of why people behave in a certain way in relation to their dispute management behaviour. We've also seen from the behavioural and the neurosciences and other sciences ideas about why people will be influenced through an opt-out clause much more than they will be influenced through an opt-in clause, and how that can have a massive impact on people's behaviour. So if we know this, right, and we've